Lord, whichever way your lordships were to look at this, Lord, democracy, federalism, rule of law, Lord, constitutionalism, each one of them is a basic structure of the Constitution as has been held by your lordships. Every one of those principles of Lord, basic structure are not completely thrown out of window by exercise of this power by the president. Now, Lord, there are three broad arguments which have been raised on behalf of the government of India. One, that Article 370 is temporary. Two, that presidential exercise under sub-article 3 of Article 370 is a valid exercise. And three, of course, that the state reorganization is a valid piece of legislation. Now, Lord, let me begin by, Lord, pointing out that, Lord, in Coelho, your lordships have expressly now said, Lord, para 137, just kindly make a note, I'm not going to trouble your lordships taking to the paragraphs. Para 137, Lord, quoting Sirvai, that there are two powers which are fiercely independent. One is the constituent power, which is a plenary power. The other is a power of amendment of the Constitution, which is a derivative power of the plenary power. So power of amendment is always not conferred by the constitutional framers, and that power must be exercised within the four corners of the Constitution. We have now a third situation where there is a constitutional power to be exercised by the President of India. Now, my Lord, first and foremost, as your lordships have brilliantly put it time and again, nobody is imperium in imperio under our Constitution. Lord Digvijay Mote is a judgment where your lordships very brilliantly, Lord, put this. 1993, 4 Supreme Court cases 175. 1993, 4 SCC 175. No one is an imperium in imperio in our constitutional order. It's reasonable to hold that the election commissioner cannot defy the law armed by Article 324. Now, can President defy Article 370 merely because he has power under 370, which he assumes to have the power? Now, my Lord, second principle that your lordships have brilliantly not put beyond pale of doubt is that there is no unreviewable decision under our constitutional order. Every decision is subject to judicial review. Nothing is unreviewable. Parliamentary laws are subject to review. Executive orders are subject to review. Constitutional exercises are subject to review. And that's not where this democracy survives. Now, in fact, Lord, in Coelho, your lordships go a step further and say that merely by inserting the words constituent power in Article 368, the Parliament has no greater power than power of amendment. It's not an original constituent power. They may have used it, and that's why, Lord, in Minerva Mills, your lordship struck down sub-articles 4 and 5. Precisely for that reason. So, power of amendment, your lordships have consistently held, is subject to constitutional limitations. Now, how do we, therefore, Lord, look at this? Lord, your lordships have always said, and this is very, Lord, interesting, as Saman puts it, Lord, the duty of judicature is to act upon true intention of the constitutional framers, the Constituent Assembly. That means sententia legis. How do you gather that intention? Can you travel outside Article 370 as what the government would like your lordships to do? In my respectful submission, no. The entire basis of the arguments are circumstances prevailing today to justify this exercise, and then to persuade your lordships that this is what Article 370 means, and that's why it's temporary in nature. Now, my lord, don't take anything. 300. Lordships have said that, Lord, your lordships have liberty to, Lord, interpret the constitution within permissible limits. Your lordships have always, Lord, upheld that principle very soundly. But the government wants your lordships to read something which, Lord, I find it very difficult to understand on a plain reading and clear intention of the constitutional framers. Lord, these were men and women of extraordinary wisdom. They've worked for over 2 years to draft the constitution. But whatever their intention was, they have put it in this article. We don't need to travel outside at all to find out what that intention is. And that intention is in 371C. Please see 371C. Don't turn to it. It says, provisions of Article 1 and of this article shall apply in relation to that state. So they have permanently embedded 370 into the Constitution along with Article 1. Having embedded that, because it is through Lord 1C that 1A, B will not come into play. Because they have now said 370 shall apply in relation to Jammu and Kashmir. Now, Lord, they were aware that, Lord, they had some understanding with the state, where state wasn't sure whether it wanted to continue this association with us or not. So they, Lord, therefore drafted sub-article 3 to say, notwithstanding anything in the foregoing provisions of this article, on the recommendation of the Constituent Assembly, I am paraphrasing it, on the recommendation of the Constituent Assembly of the state, President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions. Now, my Lord, can any other meaning be given to the expression Constituent Assembly? Contrary to what they had said, because that's also used in sub-article 2. Today, Lord, after 70 years, you might say, read Constituent Assembly to mean Legislative Assembly, and legislature to mean Parliament. Lord, I respectfully submit that this is the limiting provision. The temporary nature of the article is in sub-article 3. Because they wanted to give people of Jammu and Kashmir, through the Constituent Assembly, the right to decide whether they wanted to continue with India, whether they wanted to follow Constitution of India or not. Nothing more, nothing less. Otherwise, 370 is embedded into the Constitution. And it's not temporary, it's permanent. An exercise under sub-article 1 is therefore permanent exercise to be done from time to time. for principle of contemporaneous exposition. For 70 years, if government of India, order after order after order, exercises powers under Article 370, can it now lie in their mouth to say that Article 370 is temporary? That's how they've understood. That's how they've acted. Merely because government has changed of a new party, does it mean that it has suddenly become overnight temporary? This is something which I want your lordships to kindly appreciate, that 370 was never intended to be temporary in its heart and soul. Only temporary nature was to give the right to the Constituent Assembly to decide what do you want. If they had decided, no, we don't want it to continue, President could have issued the order. Instead, they said, no, we want to be part of India. We want Constitution to apply. But we want it to be applied in the sense of Article 371. And two, essentially one, consultation and concurrence. Is it not something extraordinary that is being done? It is not the case of Government of India that 370 has not worked over last 73 years. Not one example to show that 370 has failed. Every time the Government of India wanted to apply anything, any article which was left out or any law which had to be applied, it was automatically accepted by state of Jammu and Kashmir and its assembly then and subsequently state governments. So it is very unfathomable that why is it that suddenly overnight you get up and say now. And that's not something which your lordships must appreciate. I've said in my written submissions earlier. In their manifesto, BJP categorically says in 2019, we reiterate our position since the time of Jansang to the abrogation of Article 370. This is the only material with the President of India, nothing else, with greatest respect, in all humility at my command. They wanted to have, because Jammu and Kashmir and 370 has become a bone of contention in this country amongst some sections of society. But nobody has understood what 370 is. 370 is integrating Kashmir into India. And your lordships say again and again in the two judgments, which I will now straight away refer to. I respectfully submit, your lordships must very carefully scrutinize Kaul's case, Premnath Kaul, and Sampath Kumar. Both judgments support my submission on every point. Both answer to what the Government of India has said, and they both provide answers to the questions that your lordships have raised from time and again, including on sovereignty. I'll read just 4 paragraphs from each. PDF page 10 in Premnath Kaul, it's volume 1, it starts at page 7. Just note, don't turn to it, unless your lordships have time, because we are running against time. But this is what your lordships say. PDF page 10, volume 1, page 7, it starts at 10. Clause 8 is very important. It says that nothing in the instrument affects the continuance of Maharaja's sovereignty in and over his state, or save as provided by or under instrument, the exercise of any powers, authority, and rights then enjoyed by him as the ruler of the state, or validity of any law then in force in the state. Then, your lordship say, after the act was enacted by the Yuvraj, my Lord Chief Justice rightly queried, after the act was enacted by Yuvraj, he issued a proclamation on April 20, 1951, directing that Constituent Assembly consisting of representatives of people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing constitution of a state of Jammu and Kashmir. In accordance with this proclamation, Constituent Assembly was elected and it framed the constitution. Then your lordship says something very important, but it is urged. This is PDF page 16, para 26. But it is urged that sovereignty of Maharaja was considerably affected by provisions of instrument of accession which is signed in October 25. This argument is clearly untenable. It doesn't stop here. Even subsequent proclamation onwards, your lordship say his sovereignty continues to legislate. And your lordships, when your lordships were called upon to decide whether a matter should be referred to a larger bench or not, your lordship said that there is no conflict between Premnath call and Lord Sampath Prakash. Therefore, your lordships declined to refer it. And your lordship said law precedent binds us in that judgment. So, my lord, these two judgments, in my respectful submissions, are binding on every point that's been raised. Now, see further. It is true, my lord, it is true that by clause 1 of the instrument of accession, His Highness conceded to the authorities mentioned in the said clause the right to exercise in relation to his state such functions as may be vested in them by or under Government of India Act 1935 as in force. Now, my lord, this
No, Mr. Dwivedi, we made it clear that 4 o'clock today we are concluding. Whatever now remains, you can give us submissions and rejoinder. Because even in rejoinder, now we have heard 5 counsel. We have heard Mr. Sibal, Mr. Gopal Subramaniam, Mr. Zafar Shah, Dr. Rajiv Dhawan, and now Mr. Dave is on his legs. So I think 5 counsel in rejoinder is I think
lordships may
broad.
at least give 15 minutes today extra, if possible.
The thing is, I had said when we were arguing petitions, we were cutting down our submissions to argue and rejoin.
So what we'll do is
No.
we will
Instead of half an hour, you
State reorganized.
half an hour you were in 2 hours, so you can't say that you want to argue and rejoin us.
what we will do is we will
Questions on the state reorganization, the specific.
we will continue for 15 minutes. We'll wrap up at 4:15. After that, anybody wants to give us anything in writing, not more than 1 page, to just sort of highlight the bullet points.
I would need about 10 to 15 minutes. Now, I'm only on the State Reorganization Act.
With no
Now,
difficulty, but all within 4:15. We have to write it. 4:15 will be right.
But some
I'll
latitude.
continue with
And
Attitude
4:15.
is 4 to 4:15.
Because the half day on Monday was taken by the respondent, which your lordships had actually apportioned Monday and Tuesday to us.
But then you also took the half day the previous week, you know.
So,
9 days. 9 days
9
to
days.
precise for arguing and opening.
Anyway, no,
1.5 days in rejoinder.
So
let's
what
not
we'll do
complain
now
about
is
time.
that, what we'll now do is, we'll exactly at 4:15, we will say that we have heard arguments, judgment is reserved. Any further submissions and rejoinder may be submitted within a period of 3 days, not exceeding 1 page for each of the
conclude,
rejoinders.
I can. I didn't get even 10 minutes. I've been requesting all of them.
We are here till 4:15. After that, this will be the order which will be recorded.
Yes.
That
Don't interrupt,
one page of rejoinder
So,
submission.
Lord, this is what your lordship say in paragraph 31, PDF page 17. It's true that by clause 1 of instrument of accession, His Highness conceded to the authorities mentioned in the said clause the right to exercise in relation to state such functions as may be vested in them by Government of India Act as in force. But this was subject to other terms of the agreement of accession. And clause 6 of the instrument clearly and expressly recorded continuance of sovereignty of His Highness in and over his state. There is no substance in this argument. They rejected the argument on behalf of the petitioner that sovereignty had come to an end. Then, my lord, your lordships further said, my lord, one paragraph.
Mr. Dave, we'll look at call. Call has been
Yes.
read over.
No, but this is little important because this answers all questions. To my mind, my lord, respectfully, my lord, I may say so, will not be at the cost of repetition, that every one of the arguments raised by them stands covered by these two judgments. And they have not explained these two judgments in their arguments.
Paul and Sampath
Paul and Sampath Kumar. Sampath Prakash.
Yes.
Now, please see. Lord, Article Clause 2. This clause shows, Lord, this is on Clause 3, sorry. Thus, the proviso to Clause 3 also emphasizes the importance which was attached to the final decision of the Constituent Assembly of Kashmir in regard to relevant matters covered by Article 370. This is not PDF page 17, para 31. Then, my lord, your lordships say at page para 40, the constitution makers were obviously anxious that the said relationship should finally be determined by Constituent Assembly of the state itself. Please see this, my lord. Paragraph 40, PDF page 20. Constitution makers were obviously anxious that said relationship should be finally determined by Constituent Assembly of the state itself. That is the main basis for and purport of the temporary provisions made by the present article. And so the effect of its provisions must be confined to the subject matter. The temporary nature, according to your lordships, Lord, in Premnath call was till Constituent Assembly, Lord, approved it. It did. President accepted that approval and issued, Lord, presidential order.
Yes.
So, my lord, this is completely, now, my lord, neither subsequent proclamation issued by Yuvraj Karan Singh adopting as far as possible proposed constitution, nor constitution order subsequently issued by president purported to impose any limitation on the legislative powers of the ruler. So, my lord, your lordships have held that the sovereignty of the ruler continued even after, my lord, the acceptance of the constitution, after Article 1 was applied, after, my lord, presidential orders were issued. Lord, in Sampath Prakash, your lordships, Lord, have gone a little further and said, Lord, this is what your lordships say. Now, my lord, in Sampath Prakash, just note this is very important. My lord, PDF, my lord, volume 1, page 4, at page 30, page 29-30. My lord, these very arguments were raised by the petitioner there. The first argument was that article contained temporary provisions which ceased to be effective after Constituent Assembly convened for the purpose of framing Constitution of Jammu and Kashmir had completed its task. Then what are the grounds they give in support of that? They say, my lord, these special circumstances to which reference was made by him were, one, there had been a war going on within limits of Jammu and Kashmir. There was a ceasefire. That conditions in state were still unusual. That part of the state was still in hands of rebels. And that country was entangled with United Nations in regard to so-and-so. Noting all these arguments, your lordships, my lord, rejected the argument that it is temporary. Lord, at para 7, at PDF page 30, your lordship says, Lord, very emphatically, there are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after the Constituent Assembly of the state had passed the Constitution of the state. Then your lordship say, in fact, no such recommendation was made by the Constituent Assembly of the state, nor was any order made by President declaring that article shall cease to be operative. On the contrary, it appears that Constituent Assembly of the state made a recommendation that article should be operative with one modification to be incorporated in explanation. This modification in article was notified by President by Order 44, laid down that from 17 November article was to be operative. This makes it very clear that the Constituent Assembly of the state did not desire that this article should cease to be operative and in fact expressed its agreement. Please allow me. This article, this makes it clear, PDF para 7. This makes it very clear that Constituent Assembly of the state did not desire that this article should cease to be operative and in fact expressed its agreement to the continued operation of this article by making a recommendation that it should be operative with this modification only. In view of these provisions, it must be held that Article 370 of the Constitution has never ceased to be operative. What are they arguing, my lord? Can Government of India, in the face of law declared by this court under Article 141, say that it has ceased to be operative? Or that it was temporary? Never ceased to be operative, and there can be no challenge on this ground to the validity of orders passed by President in exercise of powers conferred by this article. The argument was that presidential orders are without authority of law because Article 370 has ceased to be operative. They said no. Why? Because they said Constituent Assembly agreed that it should be operative and it was continued thereafter. So what 5 learned judges of this court in both these judgments have categorically held. Now, my lord, so far as amendment of Article 368 was concerned, as my lord applied to Jammu and Kashmir, your lordship said only one thing, that thus Article 368 is not primarily intended for amending the constitution as applicable in Jammu and Kashmir, but it is for the purpose of carrying out the amendments made in constitution for rest of India into the constitution as applied in state of Jammu and Kashmir. Brought PDF page 33, para 13. So your lordship went to the extent of saying that those provisions of amending the constitution there is no time to read anything. So, my lord, your lordship went to the extent of saying that amendment to Article 368 insofar as J&K is concerned is not for the purpose of amending constitution. It is only for the purpose of ensuring that amendments in Constitution of India are effected in Jammu and Kashmir. Expressly, your lordships hold that. These two judgments, therefore, now, my lord, the union has relied on Damnu's case. But Damnu does not, water down this position at all. Damnu, in fact, my lord, volume 1, PDF page 45 says that necessity of concurrence of the state government or consultation of state government is a must for the purpose of Articles 371A and 1B. And therefore, they said that they place no limitation on Jammu and Kashmir constitution. So Damnu was an entirely different situation. Now, my lord, as I said, Lord, in my opening arguments, what is the situation? So, my lord, suddenly the British decide to leave. There is a vacuum. By the Independence Act, they said that now there will be 2 dominions, Pakistan and India. The territories will be those which were part of British India, subject, of course, to the princely states agreeing to come into India or Pakistan, as the case may be. So, my lord, these accession treaties were entered into. Now, my lord, if that is so, then, my lord, as Berubari expressly holds, if a treaty has been incorporated in the constitution, 370 is a classic example of incorporation of that treaty. My lord, Clause 6 of the instrument of accession is bodily lifted into 370 in spirit. Now, once it is treaty has been constitutionally recognized, you cannot not pass any order to undo that. Lord, the whole what was the purpose? Why were the constitutional framers so conscious of it? Because they wanted to bring about some kind of a resolution which will be permanent in nature, to solidify relationship between Jammu and Kashmir and India. It was not for the purpose of temporarily joining them. They wanted to solidify the relationship of J&K with India. And they realized that the only way we can do it is through the means of Article 370. Because any other way, we would have lost Jammu and Kashmir. So they were very conscious. Now, can we go behind what they have done or what they have expressly referred to in the article itself? So Berubari expressly holds that if it is a treaty, and if treaty has been recognized by the Constitution, then the only way you can undo it is by amending the Constitution. And Berubari was a case of physical territory. Now, Reorganization Act is a classic example of physical territory of Jammu and Kashmir, which came into India by a treaty, now being subjugated or divided or dismembered into union territories. And you are relying for that purpose a legislative power of Parliament to do it, without amending the Constitution under Article 368. Berubari says that you can only follow constitutional amendment under 368 and the strict procedure prescribed thereunder. Nothing else, nothing more. And it defines sovereignty very beautifully. Now, therefore, these are examples where history, your Lordship knows, from 1921, there was a war which went on in Northern Ireland. In 1998, British Parliament had to concede. And the Northern Ireland Legislative Assembly was given away many powers which British Parliament was exercising, because they wanted permanent peace. Now, it's not that people of Jammu and Kashmir will die if 370 is not taken away. It's not that. Question is that people have a right to feel that what was understood constitutionally, a constitutional promise, can it be taken away in this manner that has been done? The whole, they are also citizens of India. They are not some foreigners. You are taking away from a sizable section of citizens of India a special status which was conferred upon them by constitutional framers. Parliament, merely because Parliament has majority, does not have a right to scrap Constitution. Constitutions live for eternity. And there is nothing, even after 2019, violence has gone on unabated. Every week, we find people are being killed, soldiers are dying. You have almost 1 million troops in Kashmir. You travel from Srinagar to Pahalgam or Gulgar, every 100 feet, armed policeman is standing from paramilitary forces. Hundreds of vehicles fly on those roads. So, this argument that there is development, and yes, tourism has developed because Kashmir is not the most beautiful place on earth. It's heaven. Anybody who has been to Switzerland will tell us, and Mr. Sibal will tell us because he has seen it much more than I have, that Kashmir is far more beautiful than Switzerland can be. Switzerland is manicured and pedicured.
When we go for official visits, we don't see Switzerland.
So, what I am respectfully submitting, that ultimately people have a right to expect that their status, their rights are respected for longevity. It's a lifetime's promise. It's not a promise for the moment.
Yes.
So, my lord, we are seeing, as Lord Dr. Dhawan rightly referred to Israel, what are we seeing today? For 56 weeks, not today, 56 weeks, the constitutional amendments taking away powers of the Supreme Court, Lord, are being resisted by thousands and thousands of people from across the society, civil society, business community, labor unions, lawyers, soldiers, serving soldiers. Everybody is up in arms. Why? Because Constitution is so dear to us. Lord, it must remain in our heart. Lord, if constitutional morality is allowed to be tempered with, trifled with in this fashion, then Lord, nothing, Mr. Courtmaster. Mr. Courtmaster. Lord, constitutional morality, Lord, as Lord Grote says and Dr. Ambedkar quotes him, Lord, constitutional morality must be in the heart and bosom of every citizen. Let us not, Lord, allow union to, Lord, steamroll so that, Lord, people lose, Lord, their love and affection. Now, Lord, there is one aspect on federalism that I want to cite from Lord Dr. Ambedkar's Lord debate, which is very important, Lord. In his closing remarks, this is what Dr. Ambedkar said brilliantly.
That was read out yesterday. Actually,
No, this part perhaps was missed out. I was hearing it.
Yes.
Lord, there is only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities.
It was read.
Yes.
You
Now,
don't
Lord,
read it, you
this,
noted it.
this aspect is very important because he calls basic principle of federalism is that legislative and executive authority is partitioned between center and states, not by law.
Yes.
Now, if Constitution has conferred this special status, then, Lord, I respectfully submit.
This is volume
Lord,
8, page 5, and volume 8, page 1299.
Lordship.
Mr. Giri, you read out it,
Yes.
this extensively.
Now, Lord, Mr. Giri, Lord, read also the aspect of whether democracy will be lost. Dr. Ambedkar says further, which he certainly didn't read. Democratic system India lost. Will she lose it a second time? I do not know. But it's quite possible in a country like India
This was
that
also read.
democracy.
This was also read.
This was not read. I was sitting. From its long disuse, must be regarded as something quite new. There is danger of democracy giving place to dictatorship. It's quite possible for this newborn democracy to retain its form, but give place to dictatorship. In fact, if there is a landslide, the danger of second possibility becoming actuality is much greater. Happened in 75. It happened in 1975. We cannot, Lord, these are not Dr. Ambedkar's every word, Lord, in the opening and the closing speech is not it must be written in golden letters by us. It should be in our heart. We cannot, Lord, overlook the fact that, Lord, ultimately, Lord, as Burke says and Ambedkar quotes him, that you can't rule by force all the time. And if you have to rule by force, then there is no governance at all. So I respectfully submit that your lordships may, Lord, kindly accept the interpretation that, Lord, we are canvassing, that 370 is permanent in nature and that sub-article 3 was temporary in nature. That power was exercised, it was exhausted. And, Lord, in place of Constituent Assembly, it's a fraud on Constitution, Lord. To say that now, Lord, Legislative Assembly, Governor, President, Parliament, everybody can exercise powers in respect thereof. How do you, Lord, ascribe? It's doing violence to the plain language of the constitutional framers. And that, in my respectful submission, Lord, your Lordship's court have never permitted. Ultimately, it's your Lordship's court which has always upheld rule of law. So, Lord, I respectfully submit that these writ petitions deserve to be allowed and the orders deserve to be submitted.